members to our third webinar. We are going to discuss today navigating labor relations under COVID-19. And I would want to take you through the program that we are going to rely on during the session. Yes, the theme is navigating labor relations during coronavirus pandemic. Our program is such that we are going to have the Executive Director of FKE doing opening remarks, where she's going to touch the latest developments in FKE advocacy in support of members, and followed by the role of social partners in labor relations and how the social partners and members can get involved in navigating labor relations during coronavirus pandemic. Thereafter, I'll come in and take you through the topic that is navigating labor relations during COVID-19. I will look at the impact of the pandemic on the three pillars of social dialogue on which our labor relations is anchored. And I'll touch specifically how we do negotiations, how we do signing of CBS, and as to whether or not it is possible under the present circumstances. I'll also look at implementation versus suspension of CBS. And I'll conclude by looking at how to administer pay cuts and paid leave, and really what is the way forward for social partners under the prevailing circumstances. And once I'm done, then I'll hand over to Grace Kaome to moderate the question and answer session. And at the end of it, we'll invite the Executive Director to do our closing remarks for the day. And with that, without much ado, I would want to invite the Executive Director, Jacqueline Mugo, to take us through the opening remarks. Welcome, Edie.
Good morning, members. A very warm welcome to you all who are taking part in this third webinar that we are conducting as the Federation of Kenya Employers. So far, we have had two other webinars. In the first one, we shared with you what we were doing at that point in helping the nation deal with the COVID-19 crisis. We were engaging with government, we were engaging with the unions, and also preparing memorandums and proposals to the government. And we shared with you the results in the second webinar, where the government gave positive responses and support to industry to help cope with the impact of the pandemic. In the webinar we had last week, we were looking particularly at the issue of the employer and the employee and the relationship and how to manage the contracts given the stresses posed by COVID-19 and the fact that many people are having to work from home or to stay home. And the issue that keeps coming up is how do we deal with the employees who are at home? How do we handle the employment contract? And we gave you strategies which you could consider as employers in managing employment contracts during this COVID-19 pandemic. We saw last week that there are very many different types of contracts. brought about by the variation in the nature of work done in various sectors and in various industries. We have piece rate workers, we have casual workers, we have part-time workers, we have contract workers, and we have permanent and pensionable forms of contract. So the key issue that arose is the element of frustration of contracts and outside forces coming to impact that employment contract, what we call in law force majeure, and whether this applies in this scenario and how to deal with it. We then answered many questions that you posed, both directly during the webinar and after the webinar, because many of you sent in questions, and we encourage you throughout this session today to continue sending us your questions, which we will respond to in similar manner. So today, as we looked at the developments, we decided on the topic that we are focusing on today, which is basically looking at labor relations and how that will be managed. The role of labor relations and that of social partners in managing the current crisis cannot be overemphasized. The social partners need to play a very strong role to avoid the collapse of some struggling enterprises and also to protect jobs. It is a joint responsibility, and social dialogue is needed to foster stability in the economy and support the recovery of the nation from COVID-19 pandemic. And we are continuing to engage the union and the Ministry of Labor through the normal structures of dialogue. We are grateful to the Minister of Labor that he has taken leadership in calling the parties to a meeting and ensuring that the labor sector is able to respond to the current crisis. These discussions are continuing, and as we speak, we are in the process of fine-tuning specific proposals that FKE would forward to the government for consideration, so that we have strategies that address both the needs of industry and the needs of employees, because the fact is that post-recovery, people will still need their jobs, and we need to ensure that enterprises are sustainable as much as possible. We have also appealed to you as members to get involved. Get involved in these engagements which we are having by giving us inputs into the memorandum and the positions that we take on your behalf. As we speak to government, it's important to show that these are views from members, and you can do that by emailing us. You can also get involved in a survey that we are carrying out with the support of the International Labour Organization to see the impact of COVID-19 on you as employers. Please respond to that questionnaire. It's fairly short, and we'll then collate that information. And based on the data and the trends that unfold, the government will be able to make an informed decision with our input as a federation on what is needed to support enterprises. We are also grateful to a few members who've made contributions in kind. There is need for masks, there is need for sanitizers, there is need for education and awareness raising at this time. And we are very grateful to members who have decided to partner with us in donating items that we are then sharing out with other members in other sectors who need them, in terms of sanitizers and the other materials that are needed at this time. And we encourage you to continue doing that so that we can get practically involved in supporting the government in the measures they are taking to protect the lives of Kenyans. Today, I am very pleased to introduce to you our Senior Industrial Relations Officer, Moses Ombok, who will do the presentation on navigating through labor relations at this time of COVID-19, after which we look forward to our engagement through your questions and answers. So once again, a very warm welcome to you all.
Thank you, the Executive Director, for the wonderful opening remarks made to members. I can see many members appreciating from afar. We are happy now to take you through the presentation on navigating labor relations during the COVID-19. Okay, welcome once again, members. As I have said, we are taking you through navigating labor relations during COVID-19 pandemic. And our first concern, which will make the main area of our presentation, is around the three pillars of social dialogue. And I would want to take you back to the International Labour Organization definition of social dialogue. The ILO working definition refers to social dialogue as any form of negotiation, consultation, and exchange of information among tripartite social partners. And when we talk about the tripartite social partners in Kenya, we are talking about the interaction between the government of Kenya through the Ministry of Labor, and we are talking about the input of Federation of Kenya Employers and KOTU in determining the labor relations in this country. Now, labor relations can only be sustained through social dialogue. And as I've mentioned, the social dialogue pillars that we rely on as a country are 1, negotiations, 2, consultations, and 3, exchange of information. Our first concern would be, how can we navigate labor relations during COVID-19 as tripartite social partners? The government has already directed that we maintain social distance, that we cannot meet. And there are so many regulations that have been introduced. How has it impacted on the labor relations? That would be our concern for today. Now, as we engage in labor relations, there are matters of common concern for the tripartite social partners, where we have what we call a meeting of mind. It is in the employer's interest, the government's interest, and the union's interest that jobs must be secured. It is also the interest of the three social partners that businesses should be sustained. And you cannot sustain businesses without engaging in productivity and service delivery in an interrupted way, so that you can deliver goods to the market and deliver services to your clients. The three social partners are also concerned about how to create the conducive environment for doing business. You can see what COVID-19 has done to the business environment. It is not going to be business as usual. And lastly, the three social partners are interested in creating sound labor relations so that we can engage in an effective dialogue. Now, I'll begin by looking at the Cpa negotiations and their implementation. And I'm looking at the government directive that, 1, has suspended meetings. It means Cpa negotiations cannot take place both at bipartite level and tripartite level. The reason being that as we negotiate the CBAs traditionally, we have been doing face-to-face meetings, and now we have to keep social distance in support of the government directive. We also have CBAs that are pending that were due for negotiations. We also had some that had been concluded that are yet to be signed. Where do we go? That is the concern. But most importantly, we are looking at the implementation of financial clauses in the collective bargaining agreement, which I would stress has really presented a serious sustainability test in the wake of business closures and in the wake of regulation of working hours. Many employers are already recording low production because we used to work up to 5. Today, we are required to close our factories by 4 so that we obey the order on curfew. And I would also want to draw your attention to what has happened in the hotel industry. The hotels are now a no-go zone. Most of them have retained security staff, maintenance staff, and a few staff from the catering department to support the staff that are maintaining the hotel. We are witnessing scenarios where the big hotels, have closed down, and there is no business going on there. How do you go around your labor relations under the current scenario? From the Cpa negotiations, I would want to touch what I call conciliation. I can also call it alternative dispute resolution. For the purposes of the labor matters, we depend on conciliation and mediations. Again, conciliations and mediations are done through face-to-face interaction, where the unions present their claims and the employer present their defenses, and therefore the parties meet before a conciliator. Again, face-to-face, before a labor officer, and these are done in the Ministry of Labor boardrooms. These have since been stopped because if you go into such negotiations, you are going to be at risk of contracting the COVID-19. The directive has affected both tripartite and bipartite engagement. Even at the shop floor, we can no longer engage the way we used to engage when we are processing grievances or disputes. Now the question would be, how can employers and labor unions consult and exchange information while maintaining social distance? I know that we are used to alternative dispute resolution, what we call ADR, but there is an emerging need for what I would call ODR, that is online dispute resolution. Are parties able to exchange online, especially when they're looking at the proposals and counter proposals on how certain disputes that are straightforward can be handled without necessarily meeting within the boardroom? And this has been done in certain countries where you do online dispute resolution. You exchange your proposals and counter proposals, and an expert assists you to analyze and give recommendations as to how this can be done. This can also be done in this country. Disputes regarding recognition agreements are fairly straightforward. We are talking about numbers. You don't have to meet to resolve these disputes, but you can send your proposals and counter proposals to a conciliator who will then investigate and give their verdict on how this matter can be resolved or settled. Allow me to turn to recognition agreements. This is another area where the labor relations in this country is facing a departure from the traditional approach. The law requires that labor unions mobilize members. They go out and recruit members up to 51% to achieve the threshold required to sign a recognition agreement. Under the prevailing scenario, you cannot go around mobilizing the members because it will lead to a breach of the social distance order by the government. How then can this be done? Can we suspend the mobilization process? How best can we reach employees? Of course, even where a union and the management has signed a recognition agreement, they have been frequenting business premises to conduct union activities. This cannot be done under the present circumstances. Neither can parties sign recognition agreement. The question would be, how do we navigate the labor relations under the prevailing circumstances? And here we are now. Have a look at the illustration. This is the typical social dialogue business in progress. You can see the able lady chairing the meeting On my right could be a union representatives. On my left could be the management representatives. See how close the members are seated as they interact. They are exchanging information, they are negotiating, they are consulting over matters of common interest. This cannot be done today, and this makes us call upon the tripartite social partners to think out of the box. How then can we handle our labor relations under the present circumstances, where we cannot meet in boardrooms and exchange information, negotiate or consult? This is traditionally how we have met at the labor office. This is how we have met at the bipartite level, where the union and the employers are meeting in the absence of the government officer. Okay. Now, allow me to turn into now what I would call the strategies of navigating the labor relations under the COVID-19 pandemic. These, for me, are the strategies. How do you navigate the labor relations during COVID-19? First of all, let us look at consultations between an employer and a trade union, or between an employer and a group of employees over two matters. The first matter here is about paid leave, unpaid leave, and the second matter is about the pay cuts. How do you do consultations and keep the social distance? You can see Section 10, subsection 5 of Employment Act has provided for this, and I quote, that any matter stipulated in subsection 1 over changes an employer shall do in consultation with an employee to review the contract or reflect any change, the employer should notify the employee in writing. But this should be done after consultation has been done. Now, how do we do this consultation? We need to embrace the digital platform and start consulting. We can consult even on emails. We can consult in the social media and follow this through in writing. That would still mean consultation. Because I know as we talk, there are some employers who have sent employees on leave. But when you want to vary terms, how do you reach them? You use the social media. Now, as you exchange that information, at what level do you involve the CEO of the company and the Labor Union Secretary General? It is advisable that the consultation from the shop floor involves both the CEOs of the union and the company involved in this consultation, so that the union does not feel left out. We have had complaints where the Secretary General say that, yes, the employer consulted, but they were not involved because it was only the shop floor. So you are supposed to involve the shop floor, the branch secretary, all the way to the union secretary general, so that the decisions that can be made about unpaid leave, about pay cuts, involve the top union decision-making organ. And this reduces any likelihood of a grievance or a dispute on the part of the union. Now, how about consultations leading to suspension of CPA terms? First of all, can you have a consultation and suspend the implementation of CPA clauses? Yes, you can, but with the caution that you consult the labor union about your intention to suspend the general wage increase or any financial clauses in the CBA, so that it is clear to what extent the suspension will take, how long will the suspension take, and what happens when the business is back. Are you going to talk of arrears? This should be very clear. And the intention of the employer and the union at this point is about keeping the businesses afloat and saving the jobs. That is why it is important for you to consult and reduce it in writing. As you approach these consultations, we also advise that the union and the management approach the consultations in good faith with open mind so that the problem at hand is a common problem. It is not an employer's problem, it is not a union's problem, but it is our problem jointly. You can see what is happening now. The businesses are struggling with the means of how do we reduce the cost? How do we avoid redundancies? How do we avoid non-renewal of fixed-term employment contracts? I will reiterate that we do not support the loss of jobs. We support the saving of jobs at these difficult times. That is why consultation is important, so that under the extraordinary times, we also come with extraordinary measures. And that is why consultation is important at this time. The other issue that has come for which employers are struggling with today is about regulation of hours of work. The government has directed that employees are released from various workplaces at 4 p.m. to proceed home so that they obey the curfew order. Now, most employers traditionally have worked up to 5 p.m. This should not be a big issue. You can see Section 27 of Employment Act gives the employers the powers to regulate hours of work. So it is upon you to consult with the workers, to consult with the union, and review the reporting time so that you do not lose the production, you do not lose the man hours. Again, it is about consultation. That is the tool we need to use so that we can mitigate the effect of COVID-19. How then do you consult the union without violating the Government of Kenya Directive on social distance? I have alluded to the digital platform. Makes use of phones, emails, and communicate with various union officials and follow up with writing. You may not necessarily have to involve yourself in a face-to-face meeting, because that one will be in a violation of the social distance order. And this would include consultations on the contents, the length of unpaid leave, even the extent of salary cuts, which require the involvement of the Secretary General and the respective business captains. Because pay cuts come with a lot. You need to discuss what is affected by that pay cut. Is it the basic salary? What happens to the other allowances? And what is the legal glue or contractual obligations that would still hold the employer and the union together so that it is not unpaid leave, and then you lose an employee that you have invested in as an employer for a long time because of the 3 months or 2 months unpaid leave, then they can go. So you really need to find out how do you maintain the unpaid leave. Now, in conclusion, what are we calling upon the social tripartite partners to observe? The tripartite social partners moving forward need to think about signing a framework agreement, a tripartite agreement with a common objective of managing the labor relations during the pandemic. And the ultimate goal here, as I have mentioned before, is about really how to save jobs and sustain businesses. We are also talking about the employers and the unions together supporting the government intervention on the measures towards controlling or rather stopping the spread of COVID-19. And with that, I would like to open now the session for where I'll invite my colleague, Grace Kaome, to moderate the question and answer session. Thank you. Welcome, Madam Grace.
Thank you very much, Ombok. I appreciate that session. We'll now open it up to the Q&A session. We have received some questions from our members which we'd like to address at this point. And possibly we can start from a question that has been asked by Juliana Nguli, who is asking, after consultations with employees and where there is no union, must the employer inform the labor office in case of variation of employment contracts? Ombok, you can take that question, please.
Thank you, Madam Grace. It is not mandatory, it's not a legal duty that the labor office be informed about the agreement between the employee and the employer as to how the terms are going to be varied. But good practice requires that such agreements are deposited with the labor. The reason being that where a dispute arises in the future as to implementation of those agreements, the initial complaint will be made at the labor office. So wisdom require that even after signing those agreements, they deposit a copy of those agreements with the labor ministry. And with the labor ministry, I am proposing the local or the nearest labor office at the county level. Thank you.
Thank you. So we go to the next question that was forwarded by one of our members, and it says, can we suspend the implementation of financial clauses in our collective bargaining agreement in response to the negative effect of COVID-19 on businesses? Grace, can you take that question?
Yes, good morning, members. Indeed, just a minute.
Sorry, we have a technical hitch, so maybe we'll address the next question as we wait for that to be sorted out. And so I'll request Moses to address a question that talks about whether an employer and a trade union can settle and resolve without waiting for the government to lift the bans on meetings. Are there things that we can do during this period? And I know you've already talked about it in your presentation, but maybe you can help this particular member to understand whether there are things that they can do to resolve issues they are going through between themselves at this time, even before the bans are lifted.
Thank you, Madam Grace. Yes, it is possible. You remember from my presentation, I spoke about a new concept that is foreign in this country, but it has been practiced elsewhere in the world. We are talking about online dispute resolution. What does it mean? It means that the employer and the union can exchange proposals and counter-proposals over a matter in dispute. And they trust it with a third party, a neutral third party, who is well versed in labor matters, to analyze and guide them as to the best way of resolving that problem without necessarily appearing before the expert, without necessarily appearing before the conciliator. But this can only work where they have identified a conciliator or an alternative dispute resolution practitioner who is well versed with the employment and labor relations matters. So this is possible. Thank you.
Great, thank you very much. And I'll get Moses to take a follow-up question on that before we get Chris back. And the follow-up question is asking, to what extent can an employer consult union leadership before varying terms and conditions of employment without violating the rule of keeping social distance? It's very close to it.
Thank you. I had also attempted to address this during my presentation, but I'm happy to come back and stress that nothing stops the employer from engaging the union from the shop floor all the way to the national office, and this can be done simultaneously. The idea is that you need to make the union leadership be involved from the word go and do not feel that they are being left out from the consultations. And the wisdom around it is that there are certain decisions that the union and the employer can only make where they involve their top CEOs for decision making. For example, matters of unpaid leave, matters of pay cuts. This must be done with the full involvement of the Secretary General. And that is why when you start consultation from the branch level or the shop floor, you involve the Secretary General, but you do it on a digital platform. You can write to the union and share and even follow with phone calls. And I'm happy the unions are digitally empowered today and would be happy to engage the employers through such platforms. Thank you.
Great. Thank you, Moses. So let me finalize the final one that has come through that is still on that line, and it's asking the question of informing the labor office. Does it apply if the employees are non-unionizable?
Yes, it still applies. Remember, where the employees are not unionizable, the only government agency that can scrutinize the employers and employees agreement in terms of meeting the basic or fundamental legal principles is the labor office, because they are well versed with the fundamental labor rights of the employees. And like I had mentioned, when an employee feels offended, the first office they would want to rush to report a trade dispute is the labor office. So I would still encourage that you involve the labor office, and you're not involving them so that they become part of the negotiation, no, so that they perform the advisory role that the government has established the agency to perform. Thank you.
Great, thank you very much, Moses. So we'll go back to the question that was asked earlier, and it was reading, can we suspend implementation of financial clauses in our collective bargaining agreements in response to the negative effect of COVID-19 on businesses? Grace, please take that question.
Yes, thank you very much, Grace. Indeed, even as my very able colleague, Mr. Ombok, shared, Section 10.5 of the Employment Act allows parties to have an opportunity to vary the contract. I think what is key here and what is important for members to take notice that consultation is key. You have to consult. Remember, a contract of engagement is a contract between two parties. And when you have a CBA, it is a contract that you have between two parties. So if for whatever reason, the workers are not able to perform their duties under contract, then it takes, it must bring parties together to see how they can mitigate that issue. If the employer, on the other hand, is also not able to meet his obligations under the contract, then both parties must come together. I've heard what Mr. Moses has shared, that there must be social dialogue, there must be exchange of information, and this is very key. Consultation is very key. So the key here is consultation. Let both parties sit, and then those financial clauses can either be suspended depending on your consultations and what you agree, and or they can be postponed, or they can be addressed in any other way, even if it's through pay cuts, or even if it's through renegotiating, that can be done. Then another thing that you see in Section 10.5 is that these changes should be in writing. So it is not enough to agree, but it's important that after agreeing, it is reduced in writing and both parties sign, confirming that this is what they have consulted, this is what they have talked about, and this is what they have agreed, looking at the capacity of both parties.
Thank you, Grace. So I'll take it up again, and I'll invite you to answer a question that is quite a mouthful, but it's related to unpaid leave. There are quite a number of questions that have come through asking, what happens if you'd like to put people on unpaid leave, but you have staff who are on maternity leave currently, some are on sick leave? What happens for people who still have paid leave days that they have not taken? Can we still send them on unpaid leave? If unpaid leave ends, the period that you have stipulated, if it's 2 months, what do we do after that? What happens if this period takes longer than we had anticipated? Those are some of the questions that are coming through on this issue of unpaid leave, including how long it can take. Maybe you can speak to that. Thank you.
Yes, thank you very much, Chris. When it comes to unpaid leave, I've had you talk about unpaid leave, I've had you talk about maternity leave, I've had you talk about sick leave. We must look at the provisions we have in the Employment Act. We must look at the provisions we have in the Employment Act. We have unpaid leave, which I've heard you say. We have maternity leave, we have sick leave, and each one of these is addressed differently in the Employment Act. Apart from unpaid leave, which I will come to, let me deal with maternity leave and sick leave. Remember, the Employment Act provides for sick leave. Remember, the Employment Act also provides for maternity leave. These are legal entitlements. So you cannot compromise, for example, maternity leave just because of the COVID-19 pandemic. Maternity leave is an entitlement, meaning that even if the employer is not able to meet that obligation now, it might be an obligation they will be required to meet in the future. And this is because this is an entitlement in law, it's a statutory entitlement, and both parties, particularly the employee, is owed. Remember, these entitlements have been domesticated from ILO conventions which we have ratified. This is with regard to social protection benefits. So maternity leave is a social protection benefit that is borne by the cost is borne by the employer. So it's important for us to note that that is something an employee is entitled to, and the employer needs to make good of that entitlement. When it comes to sick leave, again, we do have the provisions of the Employment Act which provide for sick leave. I know the content of the Employment Act talks about 7 days of full pay, 7 days half pay. But when you look at Section 63, I believe, of the Labor Institutions Act, which did away with the previous general wage, orders, the content of that Section 63 shows that the orders that came out from that act were not repealed. And the general order provides for 30 days on full pay and 15 days on half pay. So we do encourage best practice is that you ensure that sick leave is an entitlement, and therefore you have to pay the employee during that period of sick leave. But there are, of course, regulations that go around with it, that an employee needs to provide what we call sick offs or documentation showing that they have gone on sick leave, which we get from the doctors. The act I was talking about was the Regulation of Wages and Conditions of Employment Act. Even though that was repealed, the general wage order or the orders that arose from that act were not repealed, and so they are still alive. And whenever we have matters in court, you'll find that the court leans towards that the 30 days full pay and the 15 days, particularly if parties are aware of it and they present it as evidence in court or as their submissions in court. So that is with regards to maternity and sick leave. When we come to unpaid leave, remember, this is what we call unprecedented moves or actions that the employer is now finding themselves taking. And previously, we had unpaid leave out of a request from the employee. It used to come from an application by the employee. They want to go and study, and so they apply for unpaid leave. But at this juncture, we are facing unprecedented times when we are looking at contracts that both parties are not able to meet their obligations. And therefore, we are going back to Section 10.5 and saying, if you can consult with the employee, and these are situations both parties are aware of, then parties can come up and say, we want to vary the terms of our contract. There is paid leave, I've already consumed paid leave. Perhaps the employer may not be able to afford advance leave in advance, then they can go to a place of unpaid leave. But on the section of unpaid leave, it means that somebody is at home and they're not earning their basic wages. What about the issues that where we say employers have obligations under the law, like in terms of house allowance, in terms of deductions? What is that agreement between you and the employee? And that's why we are saying, please consult, so that you can come up with a modality of how you're going to carry out these contracts, how you'll manage these contracts, having consulted with the employee. Thank you, Grace.
Thank you, Grace. So one follow-up question. Someone is asking, is there a maximum duration of unpaid leave?
There is no maximum duration. As you can see, there is no statutory provision that says paid leave is 21 days and unpaid leave is so many. And as I mentioned earlier, that sometimes you'd find employees applying for unpaid leave, maybe to go and study, to do their master's, to do their PhD, which could take 2 years, 3 years, 4 years. This is dependent. Unpaid leave is dependent on that consultation that you have had, that communication between the employer and the employee, and where they have agreed that for a certain duration of time, this is will be a time you will be absent from the place of work. The key question here, and I think this is important for employers to take note, and the best practice, is how do you keep an employment contract alive in the event you're not paying somebody any wages during that duration? And that's why we are talking about what obligations do you still have under contract, like paying the social protection benefits. We are talking about making your contribution and the employee's contribution to NSSF, for example. We are talking about the NHIF to ensure that your employees, even during this time of unpaid leave, are able to use their NHIF card. We are talking about house allowance. Are your employees, remember the law when it talks about housing, if you look at section, I believe it's 31 of the Employment Act, it says that the employer should provide housing or accommodate the employee, or provide such sum that is suitable to house that employee, or basically to pay the rent. So in this case, do these obligations disappear? They do not. These are obligations that are attached to that contract of engagement, so that even though if somebody is on unpaid leave, what actions or what commitments is the employer still fulfilling to keep that contract of employment alive? And these are things, as I said, we can refer to section 10.5. We can look at how these things can be varied. We can look at how we can consult so that this employee for sure has some sort of what we call job security. They know that even though I'm not earning a salary during this time, the employer cares enough to, he's paying my social security benefits, he's paying my NHIF, NSSF, I am able to get my pension if they are paying for pension. I'm able also to get my housing. I'm not being thrown out by the landlord, and perhaps even some form of amount that is able to sustain that employee. But remember, the key here is consultation. There is no law that says when there's a pandemic, this is how we are going to do it. And that is where we are saying that exchange of information, that consultation is very, very key.
Lovely. Thank you, Grace. I'll request Moses to address a question that has been sent to us by Paolo, and he asks, what about the amendments of the terms of contracts if entities whose works have no labor unions? What do we do if we have no unions within our enterprise? Moses, can you take that?
Thank you, Madam Grace. That is Father Paulo, my friend. Father Paulo, what you do under the circumstances is to reach out to the employees through a town hall, but now you cannot do a town hall because of the social distance. That would require you then to do an email, reach out to these employees through email, through memos, so that they get where you are coming from. remember, the law is talking about consultation, 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 consultation. So your cardinal duty is to ensure that you consult before those terms are varied. And you must be very clear that you are varying those terms in response to the negative effect of COVID-19, so that you are not seen to be doing it without a purpose. So as long as you can consult them individually and collectively through the digital platform, nothing stops you from varying the terms. Thank you.
Thank you very much, Moses, for that. So I'll request at this point, if you have questions from the floor, who would like to ask live questions, you can raise your hand and then we'll give you a chance. So as we wait for that, we can get one more question addressed, which was asking about the tax reliefs, whether that has been gazetted or whether employers should wait for any more communication. Sorry, we request for questions from the floor. If anyone who has a question, please raise your hand. In the meantime, I will request Grace to address a question on the tax relief that were given, the 30% to 25%, whether that has been gazetted and whether employers should wait for more communication. In the meantime, if you have a question, just one or two, we'll just raise your hand before we wind up.
Yes, thank you very much, Grace. With regard to the tax reliefs that we saw, particularly the one of the pay as you earn, 30% to now 25%, when the president had his second address to the nation and he made an announcement with regard to these taxes, he was able now to clarify that the effective date was the 1st of April, 2020. There were many questions, I believe, in the first webinar and after the second webinar on what is the effective date. And he was able to clarify that it's 2020. But again, we are waiting for an official Gazette notice, which we've not yet received, which now specifies. There is one which came, the first Gazette notice, and I think there were quite a number of questions arising from it because it only dealt with the issue of VAT. However, the government is also looking at a different approach, I believe, on making in settling these issues of the reliefs, because there was they was circulated, and I believe members you received with regard to the public finance bill and with regard to the finance bills, so that there were tax bills that were now set out which were incorporating these changes. So I believe that government took the approach of making it a bill so that it's now an act of parliament. It is ratified and becomes an act of parliament. So we will keep you updated as we get more information, even from the government and from the relevant government agencies, so that we are able to now inform you on the official position as per government documentation. However, if we were to go by the pronouncements, then it is clear that the effective date is to be 1st of April. We, of course, tell employers that it's good to wait for official communication, because then that gives clarity to the issues, maybe perhaps where there would be some kind of darkness. But this is our unprecedented times. I believe the government is also doing whatever it can to mitigate these effects of Corona. And for employers, of course, we are also saying that let us see what we can do, even with these government directives coming, so that we can mitigate the impact of COVID-19 on employees and on running of businesses.
Thank you, Grace. There's one more question, and the participant is asking, if the employer pays some amount to staff who are on unpaid leave so that they are able to cater for basic needs, can that be taken as an advance later and be deducted later from their salaries? So would you like to take that, Moses? This particular employee is on unpaid leave, but the employer has decided to pay some amount to give some amount to the employer, to the employee during this time. Can that amount be later deducted as an advance from this particular employee?
Thank you, Madam Grace. This question must have come from Madam Bake. Yes, it depends on what your agreement was before you gave this advance. If you take an employee on unpaid leave will remain unpaid leave. And therefore, if you are advancing any money and therefore you want to recover this money after the employee has come from unpaid leave, then it changes the meaning of unpaid leave. And therefore, the employer has to be very, very, very clear on what advances to give and whether or not they will be recovered at the end of unpaid leave. But I would advise that we treat unpaid leave in the strict sense of unpaid leave, so that any advances made to an employee that will be subject to recovery are isolated from unpaid leave. Thank you, Madam Grace.
Great, thank you very much for those questions. We have one participant by the name Nancy would like to ask a question. Nancy, please.
Thank you so very much, team, for your very enlightening webinar. Unfortunately, this is the first time I'm joining because I was on other calls on the previous ones, and I hope I can be able to access them because this is very informative. My question is, one, if you have a consolidated salary and you want to send your employees on unpaid leave, how then do you bring about the issue of the house allowance? The second question is, if you're proposing pay cuts and you send an email to the employees, is that email as good as consultation, or must you call these employees one by one? Thank you.
Thank you very much, Nancy, for that question. I request Grace Kanyiri to take it and address.
Yes, Nancy, thank you very much for that question. I want to deal with the issue of house allowance when we have a consolidated pay. Keeping in mind that, of course, different people earn different amounts of money, house allowance would be what we know as, or what we would describe as an adequate amount for accommodation. And in the absence of maybe considering what would be adequate in terms of accommodation, there is a simple tabulation of about 15% of what the wage is. But because we know there are people perhaps who earn maybe large amounts of money, and maybe their adequate accommodation is not equivalent to the 15%, then this can be also another thing that we can bring under what we call Section 10.5, where you consult, because you're also not telling somebody now you need to move out because of ABCD, but you're also maybe considering and you're asking, Grace, where do you live? I live here, what is your rent like? And the employer can take over and maybe pay that rent or pay a portion of that rent, depending on what they have consulted. Because we also sometimes are people who live above our means. So it doesn't necessarily mean that if I'm living in a house of 300,000 per month, that becomes the burden of the employer. But we are looking at what is fair, what is adequate, and a simple tabulation would be the 15% of what this person actually earns. And we are not talking about the allowances, we are talking about the basic wage. So what is the 15% of that? And that is what would translate into house allowance. However, as I said, depending on who earns what, we are looking at the reading of the law is that you need to provide adequate accommodation near the place of work. And of course, we know that sometimes we don't live near the place of work, and sometimes we are married and we have a partner who is also paying as part of the rent and all that. So some of these things can be an issue where parties can actually consult. So it's not a must that it is the exact necessarily 15%, but that is a guide in terms of calculating in case parties are probably not able to agree, or in case you're in doubt of exactly how do you tabulate it. We commonly use the 15% through our general the general orders. Then when we talk about consultation, consultation is both parties having a conversation and both parties giving the other party an opportunity to give their say in it and to give their mind in it, so that both parties now come to a solution. So as the employer, you can say, this is what I think about this. I think you can go and take your leave days, you can go on unpaid leave, and you give an opportunity to the employee to say, but by the way, I can actually work from home. My duties are accounting, or my duties are a lot of it is consulting. I can actually work from home. I don't need really to take unpaid leave, or why can't you pay me half pay and this? But the issue here in terms of consultation is that you have considered that I had some views, you had some views, because remember, we are talking about a contract and we are talking about varying the terms which we had initially agreed. So consultation is that I've given you an opportunity to give me your views, and the employee has also given their opportunity to share their views and of course come up with some form of solution. So eventually you will agree or you may not agree, but at the end of the day, you have made a finding that this is the way we'll go. And it's important for the employer to say, even if you do not go by the suggestions of the employee, it's important for you to communicate to the employee in writing and say that indeed we have considered your views, indeed with regard to our views. However, in respect to the condition that the state of affairs, this is the decision now that we have made after making those consultations, after considering everyone's views. So yes, consultation means considering views. And sometimes you may not both agree. You may even come up with a solution that none of you had actually proposed. That might be the best way forward to maintain the business and also to keep the employee still a part of your employment. I hope I've been able to answer those questions.
Thank you very much, Grace. We have quite a number of other questions and we have received others in writing. I can see, and Rose, your hand is up, but what we request that you do at this point is that you send us your written questions, which we will be able to address and send you back the responses in view of time. Otherwise, we appreciate the participation and the engagements that we have had today. And at this point, I'd like to hand over back to our Executive Director, who will give her remarks, and then we'll be able to share the responses to all the other questions that we have received through email. Thank you.
Thank you very much, Grace. It's been interesting listening to the conversations and the questions in different permutations. And the main message I got is that there are different issues and different aspects of the same question. So we would invite you members to actually engage the Federation directly on the specific question and issue that you have, because there's no one size fits all, as we have said before. FKE is actually still open. We are operating at very minimal capacity, but we are here, still open and available to serve you online. You can contact us by email, you can telephone us. We have a hotline which we'll share with you at the end of this. If you have legal matters, the courts are actually still functioning. We are very proud of the judiciary that they were able to rally around and start online services at this time of the pandemic. And we are in the process of filing some urgent matters online, and the court is actually responding. So please don't feel that you're on your own or that you are abandoned and you have no recourse. We are still functioning and the systems are still functioning, and we are able to support you specifically. Because if you ask how to handle a specific contract, it depends on what the contents of the signed contract is. We'd have to look at the wording, and we'd have to then advise you in that context. For instance, the question about consolidated pay was very interesting, because if it's a consolidated pay, it covers housing. But we realize that it's difficult to send employees on unpaid leave because these people, staff have obligations, just like we all do. So a reasonable employer may actually want to assist the employees during this time. You cannot pay full salary. And that is why Grace is saying, and Moses, that you can renegotiate the terms of the existing contract and agree on some minimal payment, which will be factored in as part of the salary. But if you pay a consolidated salary or wage, then that is all inclusive. But we advocate as much tolerance, as much consideration as possible from employers at this time to help our employees cope, because we know that people cannot survive long term without pay. We want to assure you that we are also keeping very close tabs on what's happening internationally and within the region. There are a number of webinars still going on. There are meetings going on online at the International Labour Organization level, at the International Organization of Employers level, and within Africa, our continental body is called Business Africa. The Secretariat is actually here in FKE, and I'm the Secretary General. So we will be linking you up to the conversations that have taken place already so that you can also learn from them. One of my takeaways from this conversation is the need for simplicity. Simplicity and clarity in communication with your employees. What is it that you are proposing as an employer? And are you hearing what the employee is saying, so that there's a meeting of minds as you renegotiate and as you negotiate the current terms, even if you're talking with the unions, which is what Moses was talking about. It's very clear to be simple and clear in what you're proposing, so that there's a meeting of minds. Because one main problem we have in major relations is parties failing to understand each other. Even when you disagree, it's very important that you both understand what it is you're disagreed on, so that if you go for conciliation, if you go for arbitration or mediation, it is very clear what the issue is. The other one is business operations against the current restrictions and rules and regulations that the government has imposed to protect us. We were asked a lot of questions by members when the curfew was announced. What does this mean? If I have shifts that operate at night, does it mean I stop them? It is very clear to us from the clarity we've gotten from government that the intention is not to paralyze business or to stop business operations. The idea behind the government's actions is to protect us as citizens and as residents of this country from infection, from being infected, or unfortunately, if you're infected and you may not even know, from infecting others. So business operations still continue. The duty we have as employers is to carry out our operations between the current restrictions in terms of time, in terms of health and safety, in terms of social distancing, washing hands, and all the things that the government is talking about. So we are free to operate as business people, but of course we have to do that within what the government has wisely advised us to do, and what we as FKE have also adopted and sent you guidelines on managing the workplace at this time. Certainly free as many people as possible to work from home, set them targets, track what they are doing. The ones who cannot work from home, you treat as we've advised. First, let them take leave, then they go on unpaid leave or a reduced pay, which of course you have to do through consultations. If there's a union, consultations with the union. If there's no union in your enterprise of which it's a managerial cadre, then you have to discuss with the employee and come to an agreement. So the written word of the contract and its interpretation. Again, I think in human resource management and labor relations, a lot of it is just common sense. What is reasonable? And if you're in doubt, please feel free to consult us. That is what we are here for. Let me conclude by saying that these are times of change. These are times of uncertainty. And as Moses Ombok said, we have to think outside the box. And in fact, we have to throw away the box and do unusual things, take unusual measures, be creative in how we work to ensure that there is continuity of work. It means you invest in availing communication materials to your people, either through airtime or through laptops, so that they can work for those who need to work. Because as the great saying goes, those that can bend with the wind will weather the storm. We hope you can bend with the wind so that together we can weather the storm of COVID-19. We look forward to engaging with you outside this webinar in answering the questions you have sent and also in the webinar that we plan to hold next Wednesday. For now, it's goodbye from us at FKE, and we see you next week.